Hello, good afternoon, and thank you for joining us. We're going to go ahead and start our complete step-by-step short sale webinar. Thank you to all of you who've joined us, and we'll proceed. And please, if I can remind you to go ahead if you have any questions or if you have anything that you want me to clarify, please just type in your requests, and I'll address them. Okay. I will say that the short sale process is becoming a bit more predictable, and it's becoming a little bit easier as more and more banks come to realize that short sales are here to stay for quite a long time, and that our judicial process in the state for foreclosure is taking 2 or more years, and it's costing lenders a lot of money and a lot of time to make it through the foreclosure process. And with that being said, and a lot of individuals, just because of the way the economy is right now, a lot of individuals unemployed, underemployed. We have a lot of people out there that have a hardship and really need to get rid of their homes. And so I am seeing a lot of progress with banks and a lot of short sales being approved with a complete and full waiver of deficiency. I'd like to introduce our team. Richard Adams is the owner of the firm, and he's been in practice for over 20 years in bankruptcy and real estate. And 3 years ago, we started doing short sale processing, and I am the attorney that's in charge of the department, and I also am a real estate and bankruptcy lawyer. So I'm one thing that makes our services unique, and I'll talk a little bit more about this as we get into the webinar. But if you decide to use our services, I make myself available to help you evaluate a short sale, because as I'll explain a little bit later, short sales are complicated. There are a lot of things that you have to take into account, and a lot of things that we need to analyze, and sellers' expectations are way up there. And that's really important that we understand the seller's financial situation, what they expect out of the transaction, and that we do our homework and see what's behind this property. And we do our research to find out if a foreclosure case is pending, how far along it is, and if we have any judgment liens or tax liens against the property. Those are things that we definitely need to know up front. So I help you with all of that. I know that it can be very daunting to have a situation and to work really, really hard on obtaining a listing and getting a buyer to find out that the transaction is not cannot close for whatever reason. So those are things that I try to really help you on, is talking to the sellers and managing their expectations and analyzing the short sale for you. And that, of course, comes at no cost. Our fees, I'll explain, is paid for by the seller's lender at closing. We limit our fee to whatever it is that the short sale lender pays us. And I'll go through the package and show you how that works. But there's never a charge to the seller or to the realtor, to the listing agent. Well, I'll just start with very basically on what a short sale is. Short sale is when the outstanding loan on a property, outstanding loans and liens against the property, are greater than the proceeds from the sale. Basically, the market value of the property has dropped, and your seller owes too much. And in order for it to be a straight sale, the seller would have to come to the table with, many times, several hundreds of thousands of dollars, which in the economic situation that we're in is next to impossible. Just to give you an idea on what the lenders are thinking when they receive a short sale package, lenders are really not doing us any favors. They've come to realize and understand that there's a statistic out there that really has held true. On a subprime loan, the loss to the bank, if it takes the property through foreclosure, is about 85%, whereas the average loss to the bank, if they accept a short sale, is about 15%. And banks are now understanding and realizing that that is the case. So, they're really not doing us any favors, sellers any favors when they accept a short sale. They're making a pure business decision. Short sale mitigation and negotiation really all boils down to debt settlement. And that's what's so important about the seller's financial condition. is because it is debt settlement. Obviously, we want the best result possible for our mutual client. We want them to be able to sell their property in a short sale and be completely forgiven of any deficiency balance. And with a short sale, that is, most of the time very possible. The borrowers are able to get out from under a bad mortgage and mitigate the damage to their credit. Once a lender accepts a short sale and forgives a deficiency, the loan gets reported as paid as negotiated or settled, versus foreclosure. So that's it's really, really huge. It's a tremendous benefit to the seller because most lenders out there will give a seller another mortgage loan within 2 years after a short sale, but most lenders out there will not loan any money to a prospective buyer if they've been foreclosed on at least for 7 or 8 years. So the damage to a person's credit with foreclosure is huge, even more so than bankruptcy. We have many clients of ours that do bankruptcy that are able to qualify for a mortgage 2 years after a discharge, versus if they've lost the property in foreclosure, we're looking at minimum 7, 8 years. Right, so going on to what's going on in a lender's mind when they receive a short sale package. The most important thing that the lender wants to know is that they're receiving an offer at its fair market value. So that's why when they receive an offer, one of the first things that they do is that they order a BPO/appraisal. With that being said, I'll tell you that lenders cut corners. They don't want to spend a whole lot of money in the short sale process. I mean, they're already paying closing costs and so on and so forth. So they'll send an agent over to do a BPO. Many times those agents are from out of the area. They're completely unfamiliar with your specific area, which sometimes leads to values that are unrealistic. So that's why I ask that the realtors, in order to obtain a good BPO, which matches the listing price, to make contact with that BPO agent to basically, best case scenario, be on the property when the BPO is being done, but at the very minimum, exchange the market analysis. Let the BPO agent know how and why you priced the property where you priced it. Unfortunately, sometimes it's a BPO agent actually doesn't even come to the house. They send somebody to take pictures, and then the BPO happens within 4 walls, and that is what it is. Sometimes that happens, but most of the time you do have an agent that actually goes to the property and makes an evaluation. And when I see that where the listing agent and the BPO agent have a meeting of the minds, rarely, if ever, is there an issue with valuation. Because then when I'm dealing with a negotiator who's gotten a BPO back from their BPO agent that's $20, $30, $50, $60,000 more, it's very difficult for me to convince that negotiator that their BPO value is wrong. We do challenge it, and I rely on you guys as listing agents to help me challenge those BPOs, but sometimes it really just boils down to waiting out those 90 days for that BPO to expire and ordering a new one, and that, of course, is delay, and that's where the buyers a lot of times get extremely impatient, and I don't blame them. The bank will accept a listing price for less than its fair market value where there are problems with the property. When I say problems, I mean like a roof done without permits. Things like that are a tremendous problem for a bank when they take the property back as an REO. So if if your sellers have told you that the roof is done without permits or there's some other major issue that's going to affect the marketability of that property, please, by all means, put it in the listing. We've closed many transactions like that where it's been in the listing. We've got a cash buyer, and they're willing to take the property as is. And the bank understands why they're receiving far less than market value, and they take it. So, please, by all means, if you know that there's problems with the property, your seller tells you, put it in your listing. Banks really are their major concern, apart from, of course, the wanting to determine whether receiving fair market value, is what they're going to net out of the transaction, because in a short sale, the seller's lender pays closing costs. So that's why when we turn over a short sale package to them, the first thing they look at is the offer and the HUD-1, the draft HUD-1, where we outline all of the closing costs. And that's how they underwrite the loan based on what they're going to net in the transaction. So with that being said, we need to be as accurate as possible with our HUD-1s. That's why when I receive a short sale package, I ask for any and all demand letters that the sellers have received from a homeowners association, because I need to be able to calculate the homeowners association, the arrears, as exact as possible. I even add a little bit more so that later, if anything, the net to the bank will increase if my estoppel comes back a little bit lower. I'd rather go back to the bank and say, here, your net's going to be a little bit higher, rather than we need to negotiate this again because the HOA dues are not $2,000, they're $6,000. So that really complicates a transaction. So it's very, very important to have homeowners association dues calculated very, very accurately. Also, bearing in mind that a lot of times the lien holder, the short selling bank, will not pay more than $6,000 to a junior lien holder. Where we have, for example, a second mortgage balance that's very, very high. I'll talk a little bit about that, what I'm seeing happening with those kinds of deals. But we want to be able to know and have information on the second lien, because of course has to be put on the HUD. We also need to know, and please don't take your, the seller's word at face value. If you ask them, do you have a second mortgage, and they say no, many times they have equity line of credit, a HELOC, and they don't even know that that is a mortgage when in fact it is. So those are things that we need to definitely flush out, because my HUD needs to be as accurate as possible. We also need to be very, very mindful of whether there are any judgments against the property. Lenders will not pay any judgment liens, federal tax liens, things like that. So where we have those, obviously they need to be addressed during the short sale process, and I need to start doing that immediately. I cannot wait until I have a short sale approval letter to start dealing with judgment creditors, or to try to subordinate or eliminate federal tax liens. So those are, and again, if you use our services, I help you with that because I do my research. I find out what's going on behind this property. Many times sellers won't tell us the whole story. Sometimes they're ashamed to, or they don't even remember, or they don't know. So, we can't, we have to really try to avoid the surprises on the title commitment. Another thing to keep in mind is, before I start discussing Hoffa and the Mortgage Debt Relief Act, is if the loan has PMI, which is mortgage insurance. Mortgage insurance, sometimes it's the federal government that's insuring the mortgage, other times it's private companies. But in a situation where there's PMI mortgage insurance, we really need to be careful to tell the seller that in most situations, a mortgage insurance carrier will require a promissory note or some cash at closing. We've been very successful in negotiating that, sometimes eliminating that requirement or negotiating it down, quite far. But I always have to, make it clear to the seller that where you have PMI, it's going to be a little bit more of a challenge. And I just want to also talk to you a little bit in this, before I jump into the laws that govern short sales, the issue that I've seen, what I call the second mortgage trap. That I see happening a lot where the second mortgage balance is high. So if there's a second mortgage balance that's high, that should be a red flag for you. What I'm seeing is that the first mortgage lender usually will pay about up to $6,000 to a second lien in order for them to release their lien. I see a lot of second mortgage lien holders refusing to release their lien for less than 10% of their balance. So we have to really keep that in mind. I've seen that a lot lately, where it's basically the 10% requirement. Sometimes we're able to get the first lien to increase the contribution to the second, but other times we're not. And what's happening is that the second mortgage lien holder will require that the seller make up the difference between what the first lien is offering and the 10%. And in those situations, even where the seller is willing and able to contribute that 4% difference, the first lien holder is coming back and saying absolutely not. They're saying no. Any additional monies to be contributed by the seller will come to us, not to the second lien. And their position is that because the second lien is completely unsecured, they will not allow any additional monies to go to the second. What we've done in those kinds of instances is that we have had to actually have the either the seller or the buyer, if the buyer is willing to pay for it, many buyers are, pay it outside of closing in order to then receive an amended approval letter from the second that matches the approval letter from the first. So that's really, really important. So where there's a high second mortgage lien balance, it's immediately a red flag to me, and I notify all the realtors, and I just basically put everybody on notice that this is possibly what we're going to need to do in order to get this transaction to close. Now a little bit about the laws that govern short sales. Hoffa and the MDRA. The Hoffa is the Home Affordable Foreclosure Alternative Act, and the MDRA, which is the Mortgage Debt Relief Act. The Hoffa law is the one that allows a complete and total waiver of deficiency by law. If a loan is certified under Hoffa, the deficiency is forgiven, and the sellers receive up to a $3,000 relocation fee. It's a government-backed program. So with that being said, it does add processing time onto the short sale. 30, 60, even, many times up to like 90 days of additional processing time in the Hoffa program. It's government-backed, so there's a lot of red tape involved. And the loan has a completely different channel than a regular short sale. Even if we, for example, Bank of America's Hoffa short sales, they're not done through Equator, they're done outside. It's a traditional way with faxing of documents and things like that. So we need to be mindful of that. When my sellers want to go into the Hoffa program or qualify in the Hoffa program and their foreclosure case is advanced, I tell them you don't have the luxury of time. You just don't. Foreclosure cases, while in Florida, they still are a judicial process. The cases are moving quicker. They're moving faster. The David Stearns and the Marshall Watson's offices, those are no longer prosecuting foreclosure cases, and the attorneys that have taken over the files are moving those foreclosure cases through a lot quicker. And the judges themselves are setting status conferences in foreclosure cases when there's a period of no activity. So those 2 years dormant cases that were in the system for 2-3 years dormant, that's not happening anymore. So when I look up a foreclosure case docket and I see, for example, that a motion for summary judgment has been filed, maybe a notice of hearing already, I tell them you just don't have the time. Because once the hearing date comes for the motion to summary judgment, the judge will set the sale date 30 days out. And we don't have time to wait for Hoffa. So what I do in those instances is that I communicate to the lender that the seller is not interested in the Hoffa program, and we process as a traditional short sale. And if, in fact, the seller's financials demonstrate a hardship, there's nothing to fear. The deficiency, more than likely, will get waived. And the only thing they're going to lose, obviously, is just the relocation fee. So, but it's either, hey, you get $3,000 relocation fee, or you get foreclosed on. And with the way foreclosure cases are moving, I don't suggest that they try to wait around for a possible relocation fee. The good thing about Hoffa is, for those individuals whose foreclosure cases are not too far advanced, is that it lets us, submit a short sale package even before there's an offer. That's probably why a lot of you out there, when you're looking at MLS, you see a pre-approved short sale, for example. That's because the loan has become Hoffa certified. If the loan becomes Hoffa certified, the lender will give us 120 days to get a contract. And the Hoffa certification letter will tell us exactly the price that the lender wants for the property. So that's great, because we can definitely get the ball rolling when it's a primary residence before there's an offer. Very, very important. So when you're out there and you're taking a listing, give your sellers our short sale package. It's available directly on our website. I'll go over that. But the entire short sale package and also lender-specific packages are available directly on our website with a checklist of everything we're going to need in order to process the short sale. It's all right there, and they can start getting that stuff together and getting it over to me, and I will not waste time and wait for a contract. I will get the ball rolling immediately. And I want to just go ahead and direct you to our website. There is www.richardadamslaw.com. If you click under the short sale tab and you scroll down, you'll see our short sale package, and also at the very bottom our lender specific packages. So that you'll definitely there be able to see, and it's very, very easy to access. And so if you just scroll down there, there's non-prudential and prudential specific packages, and so it's very, very easy and convenient, and the forms even can be filled in online and just emailed to us to be very convenient for them. But they'll give you, the first thing we put in our package is a foreclosure acknowledgement form. That's for everybody's protection, yours as well as ours. The good thing about using our services is we are a law firm. We do enter into an engagement agreement with the seller where it explains to them that they're hiring us to process the short sale. It limits the scope of our representation, and it tells them we're exclusively representing them in the short sale, not in the foreclosure case and not in a modification or deed in lieu or anything else. And we help you by keeping track of the foreclosure case so that we don't lose the property, during the short sale process, but at the same time limiting all of our liability. But the homeowner short sale document checklist that tells them exactly what we're going to need in order so they can start getting their documents together. There are 2 months worth of bank statements, paycheck stubs, tax returns, so they can start putting all that aside and sending it to us. And I tell them, when your bank statements come, please just put them aside for us, and your pay stubs, put them aside for us because I'm going to ask you for them. I tell them, the short sale process is a time-consuming process, and every step of the way, the lender is going to require updated financials. The negotiator is going to, when they give the file to their upper management for review and approval, it's going to have to go in with updated financials. Just like when the file is ultimately given to the investor for final review and approval, all of the financials have to be current. So I let them know, I know you're giving me financials now, but I'm going to keep asking you every month to update them because the lender is going to require it. In order for the short sale approval to be issued, the lender has to know that they have in hand the most current and up-to-date financials, because it is, of course, debt settlement. The lender doesn't know whether you've received a large bonus, doesn't know whether you've won the lottery, whether somebody's passed away in your family and left you a huge inheritance that's now in your bank account. So those are things that, while sure it's very, very rare, but still, from the lender's point of view, especially if it's an investor that's managing the loan for as a fiduciary for a 401k or a mutual fund, they need to be sure that they are settling a debt and that they know that the most up-to-date financials reveal that the seller does not have the ability to pay. Okay, going back to the Hoffa program itself, it really is there for individuals who are experiencing a hardship, a documented financial hardship on paper. Those are people who didn't qualify for a modification, maybe because their income wasn't high enough. They weren't able to finish all their trial period payments and defaulted. Maybe they got a loan modification and defaulted on those payments. So where you see, a seller, for example, you go on a listing appointment and the seller tells you, look, I tried a modification, but the lender said no because they, said that I didn't make enough money. Or where I got a loan modification, I made 5 months worth of payments and I couldn't make any more. Those cases, tell me in my head that the lender is definitely going to accept their short sale, and 99.9% probability that the deficiency is going to be completely waived, because that tells me the lender has already seen a hardship. The lender is not going to give a loan modification to somebody who they don't believe is experiencing a hardship. The Hoffa program does end on December 31st, 2012. So, that's really important because the Hoffa program, many people have benefited greatly from it, getting the government incentive and, waiving full waiver of deficiency, no tax liability. Those are, incentives that will expire by December 31st in 2012. So if you're out there on a listing appointment and somebody tells you, no, I'll list with you, you know, at the end of the summer or sometime at the end of the year, tell them you're really going to miss out on a great government incentive program by waiting. You know, there have been some policy changes to the Hoffa program. Technically, the servicers are not required to verify that a borrower's mortgage payment exceeds 31% of the income, but I still see the banks really using that. So when I look at a person's, you know, pay stubs, I do, you know, I look at their last monthly mortgage statement. I see how much their mortgage payment was, and I kind of calculate the percentage of their income that's attributable to the mortgage, and that gives me a good idea on whether the bank would consider that under the Hoffa program or not. Another good thing about the changes to the Hoffa program is that the property can be vacant or rented within the last 12-month period. I just have to be able to supply them with independent proof that that the seller has lived on the property at least sometime within the last 12 months. So I do have to give them some sort of utility bill or water bill to under the seller's name during that period of time. The 6% payout cap to the second mortgage lien holders has been eliminated, and that's actually been quite good, because sometimes I've been able to get the lender, for example, where I have a second mortgage lien holder that's not willing to release their lien. Under Hoffa, it used to be that I wasn't able to get the first lien holder to pay more. Now I am, so sometimes I'm able to you know, increase a payout to the second lien and still preserve the seller's Hoffa incentive. The rest really has to do with like timing sequences for the bank to issue us communications and responses, and I see them really adhering to those. But you know, being a government program, it does add processing time onto the loan. All right, now going on to the Mortgage Debt Relief Act. That's an important one for a lot of sellers. Many sellers out there are really concerned about any potential tax liability on the forgiveness of the debt. Because under the IRS code, if the bank forgives a debt, it's seen as income. So many sellers out there are concerned about getting a 1099 for sometimes several $100,000. If a seller is selling their primary residence, and of course it is only for primary residences, just like the Hoffa program, only for primary residences. If a seller is selling their property and it's a primary residence, the Mortgage Debt Relief Act that will be around until December 31st of 2012, that law says that there is no tax liability, zero tax liability on the forgiven debt. So that's it's very, very important. I always direct the sellers and I tell them, if you want, read a little bit about it. I explain how it works, and I have them read a little bit about it so that they understand that there's going to be no tax liability when they're selling their homestead property in a short sale. Now, it only applies to, like I said, only applies to primary residences, and the loan has to have been in order to purchase the property. So let's say, for example, that 3 years ago the seller refinanced and used that money to buy another property or to travel or to buy a vehicle or to pay down credit card debt. That doesn't apply. It has to have been a loan to purchase the property. Now, if, for example, a seller is selling an investment property, obviously the Mortgage Debt Relief Act does not apply. But I haven't seen anybody yet, and we've processed hundreds of short sales. I haven't seen anybody yet have a tax liability because many people are insolvent, and under the IRS code, if you have more liabilities than assets, you are technically insolvent, and there would be no tax liability. So let's just say, for example, that the difference between the sales price and what the seller owes on the property, is, let's just say $150,000, and that's the deficiency. They would have to have in assets more than $150,000 in order to even be considered not insolvent. And in most cases, that doesn't happen. And also, accountants out there are really good about playing with the depreciations and bases and all that. And so even where I think somebody's very close, or may have a tax liability, I have them see a CPA, and I've never had anybody come back to me and tell me they're going to have a tax liability. So that's really important. I just always like them, if it's an investment property and somebody has a question, we're not CPAs, so I have them just make sure that they check with a CPA. But I don't, most of the time I can just tell immediately that there's not going to be a tax issue. Also, many individuals that that do short sales, a lot of them have, for example, insurmountable credit card debt, medical debt, other, hardships, other debt-related issues, and many of them end up filing for bankruptcy. And under the IRS code, bankruptcy is per se insolvency. So anybody who files bankruptcy is not taxed at all on any debt that is discharged or forgiven. So, for those individuals who are going to eventually file bankruptcy, the tax is never even an issue. Okay. Now jumping ahead to the short sale process itself, our package, as showed you, is available directly on our website, and we have the lender-specific packages. Once we receive a package, we underwrite it within 48 hours, and we send it to the lender. During that underwriting process, myself and my lead processor, Darlene Gonzalez, we look at the tax returns and bank statements very, very carefully in the financial worksheet, and it all has to make sense to me. Many times I'll get a financial worksheet that doesn't mention anything about like a second property that somebody may own, and then I look at the tax return and I see, for example, that there's rental income reported. That doesn't make sense. If somebody has rental income reported on their tax return, obviously they own a property that's receiving rental income. If I see, for example, a financial worksheet that doesn't have, has very minimal, maybe like one checking account reported with a very minimal balance, for example, and I look at the tax return and I see interest income reported on the tax return, I know that they're leaving something out. And those are things that the bank will underwrite. The banks are doing now what they should have done back when they issued the loans. They're underwriting very, very carefully. And they're looking at all those things. And they're, just like I do, they're looking at tax returns, they're looking at bank statements very, very carefully. And if something doesn't make sense to them, they'll deny the short sale or they'll ask for an explanation. They'll know there's something, somewhere in there where the seller's not being completely honest with them. I look also, to see if the sellers, if they own a business. Right away, I ask them for profit and loss statements, as I know the lender's going to ask me for profit and loss statements. Sometimes sellers will tell me that they don't have a business, and yet I go and I look at their tax return, and they have. I can tell that they do, have a business. They have a Schedule C, for example, attached to their tax return, sometimes a K-1, and I know that there's something there that they're not, being completely forthright on, or at least, having them explain what the situation is. So those are things that I help you with, and to really go through and understand what's in those financials and making sure that it all makes sense with the all the supporting documentation. Okay, once I underwrite a package and it's complete and everything looks fine, I assign to one of my internal processors who submits and process the file for me. We use a system in our office called Short Sale Commander, and that I'm privy to every single communication to and from the lender and every little status that comes in on the file. And if you use our service, for example, we give weekly email updates, and we also are implementing a program where you as agents can log into our Short Sale Commander and actually view the progress and status of the file. So we're in the process of doing all that now, and so I think it will be a really useful tool for everyone to be able to log in and see exactly what's going on in their file. I'm also available, of course, by email and by cell. I encourage you, to use my my numbers. I have my cell number right there on our short sale package. In our short sale package under the office directory, my personal email and cell phone. So many agents will call me before they take a listing or at the listing or immediately thereafter, and want me to make some contact with the seller and start to get all the documentation together, and I'm willing to do that. I know you guys as agents a lot of times don't want to get involved into a seller's nitty-gritty situation and financials, and ask a lot of those difficult questions. But that's what I'm here for, to kind of help, bring all that together. Our fees, many sellers sometimes will feel hesitant if they're being directed to use an attorney for a short sale process. They'll fear that they're going to be charged. Or what we have in our short sale package, there's a fee agreement, and that fee agreement makes it clear that they are not responsible for any part of the short sale processing fee. We put $3,500 on the HUD, and I can tell you we rarely, if ever, get that. It usually is around between $750 and $1,000, maybe $1,500, but they're never responsible for that difference. They have nothing to worry about. And when I, go through and I discuss, this, the complete short sale process and the whole step-by-step aspect of it, I like to kind of break it down into, 3 parts. And, one of those parts is knowing the seller. I really like to break it down into knowing the seller, knowing the property, and preparing, in essence, preparing the buyer. And knowing the seller, that is the most challenging part of the process. Sellers have a lot of expectations. They all want to walk away with 0 tax liability, no deficiency, relocation fees, large incentives. There's a lot of misinformation out there. They think that just because, their neighbor was able to short sell a property with Bank of America and receive a $3,000 relocation and waiver of deficiency, they should be required, they should receive the same. And really, every single short sale is its own world. There's so many different factors that come in to manipulate an outcome or to change an outcome. And they're so fact specific. You can have 2 Bank of America loans, and ultimately the individuals or the funds that own the loan are completely different. Sometimes Bank of America is merely a servicing agent, and another bank, for example, may own the loan. So there's so many different nuances that, even between negotiators, you can get different results with different negotiators. So there's so many things that come into play that I tell them, forget all of that stuff you learned on the street or somebody told you out there, because it's just misinformation. The main question that I ask, when I talk to the seller about their situation, is I ask them, okay, explain to me. What's the difference between when you took out the loan and now? What's changed in your life? What has happened? What would you explain, if I was a loan officer, what would you explain to me is the reason why you can no longer pay your, the mortgage? What's happened? So I help assess the hardship. I look to see if the seller may have, things that may disqualify them for a short sale. Like, for example, I see Bank of America, Wells, some of the larger lenders, if they will pull a credit report. They definitely pull a credit report as part of the underwriting process in a short sale. And they will see whether the seller has incurred another mortgage debt. So if they see that the seller recently purchased another property and now wants to short sell this one, many times they'll either deny the short sale or ask for a significant cash contribution to approve the short sale, because they know now you want to get rid of this one because you bought another one. So I ask those kinds of questions about any major purchases that they've made. I had an individual recently, actually a few months ago, that I asked him that question, and I asked him if he had made any large purchases, and they said no. And the negotiator called me and told me they pulled a copy of the credit report, and there was a $120,000 loan from Porsche Financial. So, the seller and I definitely had a very interesting conversation after that. To make a long story short, we were in fact able to close the loan, and the deficiency was waived, but I cannot tell you, it took about a year, and it was a tough case. So I always need to know those kinds of things up front. Very, very important. We need to know how many mortgage liens are on the property. We can't take the seller's word for it. Ask them specifically, equity line of credit. I also go online, especially with some of the clients that are perhaps a little bit less sophisticated, or maybe the individuals that, perhaps don't speak very good English. I like to do the research online to find out if there's any mortgages on the property. Some people that are, not very sophisticated, sometimes they don't know that when they signed for a loan, it was secured by the property. Judgment liens, I run a public record search to find out if there's any judgment liens against the sellers. I mean, I ask them, hey, how are your other debts? Are you paying on your credit cards? If they tell me, no, I haven't paid my credit cards in 3-4 years, that's a red flag to me. I ask them if anybody's ever knocked on their door and served them with any papers. Sometimes they say yes. Yeah, I received them, but I didn't do anything with them. Well, then I know there's got to be a judgment out there. Even when they tell me that nobody's ever, handed them papers, I still look online to make sure that there are no judgments out there. Because it's very important to know whether they've been sued to collect a debt. We can't wait until we have a short sale approval letter, run title, and find out that we have judgment liens we've never dealt with. I also ask them about repairs and improvements without permits. And very importantly, I ask them about foreclosure. If I ask them, when was the last time you paid your mortgage? If they tell me 3 years ago, but I'm not in foreclosure, I don't take that at face value. I run a search to make sure they're not in foreclosure. 9 times out of 10, they are, and they just don't know it. And I find out exactly where in the process that is. I find out about homeowners association dues. I ask them when was the last time they paid. I ask them to forward me any and all demand letters because I need to know how far behind they are. I ask them about back taxes and the IRS. More and more now I'm seeing people who have IRS liens on their property. And, municipal code violations are very important. I have to, need to find out what's going on behind these properties because those are all things we have to deal with. I've seen a lot of out there are code violations for unregistered alarm systems. It's becoming another big area of issues. So I try to ask and get up front as many answers as I can that I think that the things that I see out there are most prevalent. I try to air everything out with the sellers. Another aspect is knowing the buyer. I want them to understand that patience is paramount with a short sale. And if if it's more and more I'm seeing buyers coming with financing, I need to make sure that they're pre-qualified, that they're getting the ball rolling. They're not waiting until the last minute, to get their financing. Because once the lender gives us an approval letter, they're not gonna give us 3-4 months to close. So I need to make sure that these buyers are qualified and that they're moving ahead with their financing. Lenders nowadays are taking about 60 days or so to approve a buyer's financing to underwrite. So it's very, very important. I also ask them not to wait until the last minute to apply to a homeowners association. I've seen some homeowners association that take 6 to 8 weeks to issue an approval because they want to do a full credit background check. They want to do a criminal background check. They take their time. So we can't wait till the last minute, for the buyer to start to prepare themselves to purchase the property. Just recently what I've seen is Bank of America. Now Bank of America is completely changing their short sale procedures middle of next month. And we're going to be our team is going to be participating in a webinar to discuss all the brand new changes that are coming up. But one of the things they've already implemented is that they're being very, very careful with BPO dates. So for example, if BPOs are only good for 90 days. If a BPO, for example, was done 2 months ago and we have a short sale approval and now I need to extend the approval, if the BPO date, falls out of the 90-day period, Bank of America will put a hold on the whole short sale and do another BPO. And, there are many pockets, for example, in Dade County where the prices are going up. The prices of homes are going up, and then I'm getting another BPO back with a higher value. And I'm having to counter the buyer again and saying, well, guess what? Bank of America did another BPO. Their last one was 3 months ago. Based on, their analysis, now they're saying the property is not $250, it's $260 or $270 or $280, whatever the case may be. So I really try to avoid at all costs falling outside of the BPO date. That's why I asked the buyers to be diligent and do what they need to do with their financing, HOA applications, all that, so that so that I don't have to request extensions, because if we fall out of the deadline for the BPO, that's it. Another one's going to happen. Another BPO is going to take place, and then we are, you know, taking a risk as to if there's going to be a counteroffer or not. And with Bank of America, for example, as well, if when they approve a short sale, they approve based on, you know, the net. And let's just say, for example, that we get back an estoppel letter from an association. And even if the difference is like $300, $400, $500, if I go back to Bank of America and I ask them to contribute an extra amount to cover the estoppel, they'll tell me that's a deal change. They're turning everything into a deal change, which makes them underwrite it again, and it takes 4 to 6 weeks to get another approval. That's why I'm so careful with the numbers we put on the HUD, that they be accurate. Because if it's a deal change, it's going to delay the transaction for 4 to 6 weeks, and that's the buyer then, you know, getting upset or threatening to walk. So when I always, instead of just going back to the lender, if the difference is not too much, we counter the buyer for that and say, look, you know, the estoppel came back perhaps, you know, a couple $100 different. Do you want to wait for a deal change 4 to 6 weeks on the transaction, or do you want to pay this extra $200? You know, 9 times out of 10, they say, forget it. I'll pay the $200. Let's just get this closed. And knowing the property, that's where I rely on you guys' experience and expertise. I ask that you please value the property at its fair market value. Again, if you're not valuing it at its fair market value, put in the listing, why not? And you know, we go based on that. And just, you know, make sure you're out, you know your comparables, and we're comparing, you know, sometimes I get the negotiators telling me, you know, you can't compare apples to oranges, you know, so I want to make sure that the comparables are true and correct, and that we're setting our property at its right value. This is definitely where I rely on you. Just like when I have to challenge valuation, I rely on you to help me with your market analysis and your, you know, and your expertise, so that I can challenge valuation and you know, and hopefully get what you know, the value that we're looking for. This is, you know, definitely where I rely on you. I'll just talk to you a little bit about like the foreclosures and the foreclosure dockets. For you know, there's the 3 different, you know, counties that we mostly process in. Again, we process all over the state, but for example, we're in Miami-Dade County. And this is, when I am processing short sales, a lot of sellers, you know, for example, they, many of them are really involved in the process, and they want to be as, you know, as up to speed as possible. So I actually tell them how to check their own dockets. You know, some of them just simply cannot afford the representation for a foreclosure defense, and that's fine. If they get served with foreclosure papers, I have them send them to me so that I can see the case number, and I can, you know, help them monitor it. I teach them and show them how to monitor the foreclosure case, you know, agents as well. And most importantly, I give them what I call a template, like an answer that I want them to file in the case. Because once they get served with foreclosure papers, they have 20 days to respond. If they don't respond, the clerk will issue a default. Once they're defaulted, they lose their legal ability to defend themselves in the case, and the case will move quickly. So, you know, the gut reaction a lot of times to these sellers is to, you know, write a letter to the court saying that they can't pay because they lost their job, and, you know, and what they're basically doing by writing a letter like that is that they're making the bank's case for them. They're basically admitting that they are, in fact, should be foreclosed on. While a judge may feel bad for them that they've, you know, run into these terrible circumstances, the fact of the matter is that the contract controls. And the note says, if you don't pay, I take your house. So what I do is I have them file a response in the case that basically says, in a nutshell, that they admit that they own the property, but they deny each and every additional allegation and demand that the bank prove all the allegations in their complaint. They're just, by filing something like that, all they're doing is just making the bank do what they should do legally, is prove that they are entitled to enforce the note and entitled to, in fact, foreclose on the property. And Lewis is showing you here the mortgage foreclosure docket. Those are things to look for. You have to look and see. The dockets tell a story. For example, in Dade County, they're arranged in reverse chronological order so that you can see. I look at, for example, you see here in the middle of it, motion to reschedule foreclosure sale. And then, you just kind of look up and see, order resetting foreclosure sale. And that one, for example, is 10/6/2010. Thankfully, that was canceled. But then there was another date scheduled for November 22nd, 2010. So the dockets will tell you what's going on in the case, and they will tell you if and when there is a sale date. But like everything, it has to be monitored, because and what I find is that many sellers will not open their mail. And sometimes even banks' attorneys will not mail them notices of hearing, will not mail out any motions in the case, and the next thing you know, there's a sale date or certificate of title issue. Those are things we need to avoid. And even where we're not, for example, representing the sellers in a foreclosure case, if I see that a motion for summary judgment gets filed and the hearing gets set, I tell them to go to the hearing with their short sale package, with their contract, and tell the judge that they are in a short sale. And judges, most of them are setting the sale dates minimum 90 days out, 90 to 120 days, sometimes even 180 days out, in order to allow the short sale to happen. Because the judges, of course, want these the sellers to be able to mitigate their loss and not have a full, a foreclosure on their credit report. So they really will set the sale dates out. The problem is, for example, when there's a sale date already set, getting the judge to agree to reset the sale date is very, very difficult. You're basically asking the court to overturn its own order. That's hard. So we try to avoid a foreclosure sale date to be issued in the first place by being proactive and monitoring the foreclosure case to make sure that we don't, run into trouble and that we don't lose the property. I just want to know at this point if any of you have any questions or you wanted me to clarify any of the process. I will, tell you that, to please, if it's a primary residence, we don't have to wait until there's an offer on the property. We can get the ball rolling before there's an offer. Also, if it's a government-backed loan, an FHA loan, we definitely want to start the process moving quickly, because for FHA loans, those loans do take a little bit longer to process. They're government-backed, so we need government approval. So on loans like that, if it's an FHA loan, we definitely want to start processing as soon as possible. Just want to know if at this point any of you have any questions. Yes, we had a question that says, is a replay available? Yes, it is. We can definitely send that to you. Thank you all of you for joining us, and please, I encourage you to call me on my cell phone, email me if you have any additional questions or if anything you want me to help you with, and I thank you again for giving me a piece of your Friday. Thank you.